definitely practitioners. I think the judiciary would benefit from the book as well as one place to find a good starting point analysis of issues, precedents, and whatnot. But I think anyone generally interested in obligations of occupiers of premises, I think it's also going to be very important for insurance companies and people in risk management to understand how to take proactive measures and how to effectively serve your insureds and minimize your own exposure. I think that might be something as well. I've got a number of adjuster friends who've asked about getting copies of the book as well, because I think it'll help them, particularly arm their insureds with some information about what effective risk management looks like, proper protocols, for example, grocery store cases, what kind of records are admissible as a viable defense, and what systems need to be improved upon so they meet that test. I think maybe Em can speak to that issue as well. When you're preparing your groceries, we had this issue with contractors here in Ontario, where it was very difficult to get insurance because the number of claims against them. So they lobbied the government for a change in the notice period to the Act. And I think it would have been far better for someone to give them a copy of this book and explain what reasonable measures and proactive measures look like in winter maintenance, because the Supreme Court was very clear. There's no standard of perfection. And that defense is trotted out quite often, but the balance of what the Supreme Court and Mr. Justice Brooks of the Court of Appeal said was a really insightful analysis of what is reasonable. You can't just say, well, there's no standard of perfection, right? In the face of a statutory duty, doing nothing is not a defense. So what would be reasonable in those cases of winter maintenance? Do you have to stand there and monitor? No, you don't. But you have to take reasonable steps and inform yourself so you can take reasonable steps.
And I do think from the BC and Alberta perspective, as motor vehicle claims are winding down, we're going to see even more occupiers liability claims, and perhaps counsel that are new to this area, or insurance adjusters as well that are new to the area that have moved from motor vehicle to occupiers liability. And this book would be a really, really good way to get kind of caught up on these issues, understand the law in the area, what to be expected, and to be able to really jump in and start analyzing claims, whether you're a new plaintiff's lawyer practicing in occupiers liability for the first time, or perhaps an insurance adjuster who's just moved into this field and wants to better understand where the law is and what sort of defenses are available to them.
Even here in Ontario, motor vehicle claims are being constricted with the thresholds and deductibles. So a lot of lawyers are turning to occupiers claims, which can be quite lucrative. But they're not cases for someone to dabble in. You've got to get up to speed pretty quickly. In fact, I at one point had a significant practice of negligence claims against lawyers who made messes of occupiers claims because they didn't know what they were doing and didn't understand, or created improvident settlements and whatnot, or discouraged clients from meritorious claims that were viable and with limitation periods passed. Part of my goal is to avoid that happening. So any lawyer of any experience level can have a client call and look at the book and say, yeah, there's something here. And that, for me, that's an access to justice issue, so that people have a chance at fair representation. Whether or not the claim has merit or settles, that's a matter for the counsel and their client. But the main thing is that people have access to justice. Because without people like us doing this kind of work, victims wouldn't have anyone to advocate for them, and that would be a tragic loss.